The basic principles hold here that you should certainly expect that there could be an inspection. If you serve a large American market, be prepared for that. Emphasize quality and take the steps that you need to take to make sure that your house is in order.
Hello, and welcome to a very special episode of FDA Watch. I'm your host, Wayne Pines. I'm very excited about this episode. It's the second installment in another of our multi-episode series that we produced in collaboration with other organizations. Today's episode is the second in a four-part series we're doing jointly with Hyman, Phelps McNamara, one of the best-known, most respected boutique firms in the food and drug area. The four-part series is called Pharmaceutical Regulation, Compliance, and Policy. We're going to focus on issues such as rare diseases, compliance, generic drugs, Hatch-Waxman, drug shortages, a whole bunch of topics. So I urge all of you who have started listening to this series. We had a very, very good one with Frank Sazanowski and James Valentine from Hyman Phelps just a few weeks ago on orphan drugs and rare diseases. And this is the second in that series. I'm going to introduce our guest very briefly, and then we'll go right into it. First up is John Claud. He's counsel at Hyman Phelps. John is a 15-year veteran of the Department of Justice before joining Hyman Phelps. He served as assistant director of the Consumer Protection Branch, where he led the corporate compliance and policy unit. Welcome to FDA Watch, John.
Wayne, thanks so much.
Pete Dickos is our next guest. He's a counsel at Hyman Phelps. Before joining the law firm, he served for over 6 years in FDA's Office of Chief Counsel as a litigator, and then earlier as assistant and then associate chief counsel. Again, welcome to FDA Watch, Pete.
Thanks, Wayne. Glad to be here.
And Andrew Hull is a director at Hyman Phelps. Until January, he was an assistant U.S. attorney in the Western District of Michigan. He's negotiated dozens of complex settlements involving DOJ and FDA and DEA and other agencies. So welcome to FDA Watch, Andrew.
Thanks, Wayne. It's great to be here.
I'm going to start with a series of questions to our guest. I want all of you to feel free to jump in. We have an enormous amount of legal talent on this podcast. So I want to start out with a question about foreign inspections. And John, I'm going to ask you to start with the answers. Has there been an increase in foreign inspections of pharmaceuticals under the present regime at FDA? And what should companies know about the best practices for responding to 483s when they are inspected?
Well, perhaps exhaustively, like almost everything else in our lives, there's a modern political context to the notion of to the question of whether foreign inspections are on the increase. The answer's got a few parts to it. The first part is it's certainly a priority for the FDA. This is something that Commissioner McCary has announced. He has derided what he calls the unseemly advantage that foreign firms have, because it's very difficult for FDA inspectors to surprise foreign firms. And so as opposed to a domestic firm where they can just drive to and walk into and knock on the door of a domestic facility. And this issue is certainly also wrapped up in the issuance of an executive order in May, and then the more recent threat of a 100% tariff on pharmaceutical imports. So the data don't reveal a massive ongoing uptick in foreign inspections, but again, manufacturers should absolutely consider that it's going to be a priority moving forward, and should prepare as such. One of the things I think, Wayne, that tempers that is that this is something FDA has struggled with for years and years and years. The GAO has issued two different reports on how FDA can address this. I have testified before Congress on how FDA might be able to address this. And it's a difficult question because you have to arrange for diplomatic clearances. You have to arrange for interpreters and translators. You have to arrange for having a skilled workforce in place to do these things. And so FDA is trying to address all that. We don't know the specific details of how they will make it easier for inspectors to get into China to inspect facilities in China. But FDA announced that it was going to generalize the skill set of its inspectorate base, of its inspectorate workforce. And so what that may mean is that the inspectors will have a broader sense of how to do inspections, but they won't maybe not go as deep into a particular subject matter area as they do now. So all of this is in play. All of this is unfolding in real time. This is affected by the shutdown as well. We're currently living through a government shutdown, and the lapse in funding has made it so that only emergency inspections and needed for-cause inspections are going forward. Routine inspections are not going forward. So there are a lot of folds on this timeline that are unraveling as we speak.
Andrew, I want to ask you the same question. Foreign inspections.
Yeah, John did a great blog post on this on our FDA law blog earlier this year, and it's been an interesting one that a lot of our clients are, continually trying to understand, what are the ramifications of this, and should we expect an increase in these types of inspections? I think John's right on that. Look, they're going to keep steady. We're having a lot of slowdowns with just a regular shutdown, then also just all the diplomatic issues that, face trying to do an overseas inspection. I think, from what I've also learned is that it's a particularly difficult job to hire for. It's not an easy one to be an inspector that's going overseas. Already we have inspectors here in the FDA who are experts in their field. Sometimes they are small in number compared to the great tasks that they have to do of, visiting different facilities, and they have that specialized knowledge. And traveling overseas and trying to coordinate all of this is, can be a very difficult job. So I think that's also just been an area where, with resources, FDA's struggled to, do as much as they want to, but we definitely see that with this administration trying to make that a priority. And, I think we definitely are telling our clients to, expect that those inspections will be coming.
That's right. When your bosses tell you it's a priority, you're going to make it a priority. And I think that the folks who arrange these inspections are going to find a way that will, result in some sort of increase. Again, what that looks like specifically, where, the question of getting into facilities in China for years has been really driven by how many visas China will issue and how many they will allow. And if you're only giving out 5 a year, then there's only so much work the investigators can do given those limitations. And so there are a lot here there's a lot here that needs to be unpacked.
If I'm a manufacturer in India or in China, how should I be thinking about what's going on at FDA these days?
Well, so this is the same question, Wayne. It's such a good question because it affects everything. This administration sets policies. It's often been said it's a transactional administration, right? It sets policies that get it to where it wants to get. They get to yes on a deal, and then they work out the details. And so, and that is fine. But what that leads to is a great deal of uncertainty to manufacturers in India or in China or in the European Union. And so the basic principles hold here that you should certainly expect, especially in the drug quality space, the CGMP space, expect that there could be an inspection if you serve a large American market. Be prepared for that. Emphasize quality. and take the steps that you need to take to make sure that your house is in order. But it's also not the kind of thing that anyone can count on, and these measures may change as the trade negotiations move forward.
Andrew, Peter, do you have anything to add to that?
I think, John's right. In terms of what we would tell our clients, keep doing, keep on investing into your quality programs, your CG, ensuring that you are meeting CGMP. I think this is an instance where foreign manufacturers should be concerned about ramifications if they're not in compliance. And there should be a real drive and a real pouring of resources into making sure those aren't even issues that come up. Easier said than done, but that's, wholeheartedly agree with John on that.
I want to shift gears, talk about False Claims Act theories for liability, cybersecurity, tariffs, DEI compliance, how to respond to subpoenas. Andrew, let me start with you on this one. How I'm going to make the question very, very general and ask you to talk a little bit about the False Claims Act theories and what's going on in that area. I'll keep it as a very general topic and ask you, since the audience might not be familiar with all of the background, to try to, keep it into some, reasonable perspective in terms of, how we should think about it.
Yeah, so False Claims Act is, of course, one of the theories that I nerd out a little bit about. It definitely is part of the day-to-day life with the cases I work on. So generally, the False Claims Act is this federal statute that enables the federal government to pursue recovery in the form of monetary damages or penalties for claims that were falsely submitted to the government and that the government paid money for. So we see this most regularly in maybe a Medicare issue where a doctor might submit a bill for services that were not actually provided. The government there has a claim under the False Claims Act to obtain damages back from the doctor that Medicare paid for those fraudulent services. And the False Claims Act actually allows the federal government to collect up to treble damages, so 3 times the amount of damages, and also civil penalties. It's an old statute that goes all the way back to the Civil War. Think Abraham Lincoln and bullets and muskets that didn't work the way they were supposed to work, and that's why they created this statute. And it's really evolved into something now that touches on pretty much every different type of industry. We definitely see it in this FDA space. There's, some of those topics that you brought up, Wayne, are definitely hot topics right now in both the False Claims Act world and the FDA world. There's, you talked about cybersecurity. There definitely has been a lot of scrutiny from the federal government on cybersecurity issues. And also, DEI, of course, has come up a lot. Generally, the theory in those types of cases is that when you contract with the government to provide some sort of services or goods, and you submit claims to for those services, the government expects you to meet all sorts of different requirements. And if you don't meet those requirements, boom, you've presented a false claim to the government, and the government can seek some sort of recovery. A recent case that settled actually this summer was against Illumina. That was a manufacturer of genomic sequencing systems. So there was a medical device in that case. And the government alleged that Illumina sold a variety of these genomic sequencing devices to different government agencies. So think the VA, and then surprisingly also the military, NASA, agriculture. And according to the government, these claims were false because the software that was used in these systems had all sorts of cybersecurity vulnerabilities. And Illumina did not have, according to the government, adequate product security programs or systems in place to identify and address vulnerabilities. And here, I think kind of the kicker for the government was Illumina it was alleged to have knowingly failed to incorporate product cybersecurity in its software design, installation, and the marketing. They failed to properly support resources. And then kind of the kicker was falsely represented that the software adhered to all sorts of recognized cybersecurity standards. So the government alleged, hey, we got this thing from you that didn't have all the things that we had expected or hoped or that were contracted for. And Illumina actually ended up paying $9.8 million. It's really a settlement different from any that we've really seen before in the cybersecurity space. And as it interacts with the FDA medical device space, interestingly, medical device laws and regulations didn't really play that much of a role, at least in the public filings. But this was a case that ended up going to a whistleblower, was brought by a whistleblower. That's the other kind of interesting part with the False Claims Act, that private citizens can bring a False Claims Act case on behalf of the government. They file the lawsuit against, a company here, a medical device company, and the government then has the opportunity to investigate it, all while this is under seal. It's kept secret. There's no public filings or public filings that are available to the public. And eventually, here the government decided to intervene in the case, get a settlement, and the whistleblower gets anywhere from 15 to 25% of the proceeds. So it could be a lucrative payday for for a whistleblower. And generally, I think this was also someone who had previously worked at the company. And that's kind of the typical whistleblower case that John, Peter, I see at our firm, where it's someone walks in and they have some sort of insider knowledge, and rightly or wrongly, they've seen something that they think is wrong, and they bring that to the government's attention.
We're living in a rapidly changing world where the False Claims Act is an instrument of policy and not merely a means through which the Department of Justice examines and recovers for a fraud loss. It can be a civil or a criminal matter. The False Claims Act is a civil statute, but what you have, and what my job was when I was at DOJ, was to review False Claims Act suits to try to find attendant criminal conduct and to see if there was a viable criminal investigation that could spring forward from these civil filings. And so you really, I certainly anyway think of these as sort of civil and spawning at least potential criminal investigations and activities. And these suits affect matters of government contracts or reimbursements, right? I mean, there's a little bit of a difference. I mean, if you're in the FDA space, illegal claims to Medicaid or Medicare are often predicated on a drug or a device being misbranded in some way. And so there's a sort of natural flow, I have always found, from a civil False Claims Act case into a potential criminal FTCA case. At least that's how I thought when I was a prosecutor. Now that I'm a recovering prosecutor, I think that I think it still warrants, in this climate, real attention to that and real discussion about whether DOJ's disclosure policies should be put into place. And there are just a host of really complicated, and I don't like to say difficult conversations, Andrew. I like to say necessary conversations that we have to have with clients and with parties who are concerned.
Yeah, I've always been interested in the concept of the whistleblower. As we all know, starting in about the year 2000, there were a lot of Ketan whistleblower cases in the advertising and promotion area, off-label. I would estimate that the industry's paid $25 billion in fines. They still exist. Pete, you haven't been asked very much. I want to ask you, are you seeing any more whistleblower cases than previously? And what do you tell a company that they need to do in order to protect themselves against whistleblowers? Because the whistleblowers are almost invariably internal. So, what is the takeaway from the present environment where we have so many other opportunities for whistleblowing?
That's a really good question, and one that I think my my colleagues may be, better poised to respond to than me. I guess I would add, though, from at least historically, or how I have seen um, whistleblower cases um, come forward. Sometimes in your fraud on the FDA cases, they can take the tenor of um, I know this thing that the company didn't tell the agency, but should have told the agency. Um, and, basically there was some kind of lie to the agency that happened. And so, companies, I think, are best served defending themselves by, here is exactly what we told the FDA. And maybe it's possible that the agency was materially told, the substance of the information that a whistleblower might claim, was never provided, or kind of otherwise, a full record that maybe a single whistleblower, doesn't have, can show that there was, engagement, and that the agency wasn't, again, kind of led astray.
Kind of to build off that too, Pete, I think it's kind of interesting. All three of us were in the government at the same time, all in different offices. I was working in the civil side, U.S. Attorney's Office. John, of course, working on the criminal side, consumer protection. And then, Pete's office, lots of different subsections within Office of Chief Counsel, but definitely you had colleagues there that I know John and I would have worked with who, to John's point, we were doing a lot of parallel investigations where you're working closely to figure out, one, is there some sort of criminal violation that's actually going on here? Two, is it is it a false claim issue that's under this on the civil side? But we were also working closely with FDA's Office of Chief Counsel, and I know you worked on some of those cases, but also colleagues that we all know who handled a lot of these issues in parallel to really figure out what is going on. And it's hard sometimes. You just get, like you said, a part of the picture from a whistleblower who, is very concerned. They're very impassioned. They want to make sure that the company is doing the right thing, and they're concerned about, possibly harm to patients or, fraudulent reimbursements. And it takes a lot of coordination between all the different offices to actually get down to what's happening, what actually happened, and is there actually a violation that occurred that makes the claim false or that creates some sort of criminal act. And it's not easy. You have to rely on all those experts at FDA, which I know your office had very specialized folks.
That's right.
Okay. Want to turn to one more topic before we go to our break, and that's consent decrees. It's always difficult for a company to know when and whether and how to enter into a consent decree. So I want to start out with you, Andrew, here. What are the key factors in determining whether a company should enter into a consent decree with FDA? And what advice would you give to regulatory professionals in dealing with other people within the company? And I'm going to ask the others to comment as well.
Yeah. So with consent decrees, it's one of the very powerful tools that FDA has in conjunction with the Department of Justice to hold manufacturers or firms or individuals accountable for what they see as branding or adulteration or other types of violations. To understand that, I think some of the key factors that go into whether you should agree to enter into a consent decree with the government, I think it's helpful to know, how a consent decree would even come into place. And basically, it's a provision under the FDC Act that allows the government to move for an injunction, which is pretty much, it's not for damages, it's not for a criminal cause. It's really an injunction tells a business or company, you must stop or you must do this thing. And typically it's, we see this arise whenever a company, maybe is having safety issues or they're blatantly violating the FDC Act, or really just, it can be very, just a difficult time for the company if they're trying to work through issues and have had a recall and FDA is concerned. and the company is always concerned, and it's something where FDA could just sue and try to get the court to shut the company down or to make the company do certain things. So I think that is, one of the big factors is realizing, does FDA really have something that if they were to go to court, they would have the basis to shut down our firm or to significantly restrict our firm from producing product? If FDA has a basis, almost every firm is going to want to work with the FDA to reach some sort of agreed upon structure. Usually you don't want it to be a consent decree because it can be very onerous on the firm. But if it's come to that, typically, you want to have experienced counsel work with you through the process of negotiating terms that really are kind of like a blueprint for how you're going to open up. Once you've gone through the immediate crisis or once you've figured out, good steps for remediating any issues that you or FDA have found, you want to figure out what is the path forward for where we could reopen and where FDA would agree that reopening is okay. So that's really what a consent decree sets forth. It puts a lot more burden on a company. There's usually monitors and oversight. It's a very difficult thing to enter into, and it's onerous. But the benefit is you are working with FDA, or at least within a structure that FDA has agreed with you, and the court is appropriate to go forward. Some companies can choose to fight. That's always one of the options available to a company. You can choose to fight if you think that the terms that DOJ and FDA working together are seeking seem draconian, particularly unreasonable, would completely kill the business. Those might be reasons that you would want to fight and go to court and say to a judge, look, we agree to this, but we don't agree to DOJ and FDA imposing this particular provision. This is unreasonable, or it's overbroad, or something like that. That's always an option. A lot of firms don't want to do it because you then start off on a more hostile relationship with the agency. It's less collaborative, and that could backfire in the long run.
You're touching on all these points, Adrian, and you're spinning a great web that shows how complicated this is. I mean, if you're at a point, if you're a manufacturer, a drug manufacturer, and you're at the point where FDA is coming to you with a consent decree, it was rare that in my old office at DOJ that we would take a consent decree that was based on one bad inspection. I mean, that's got to be a really bad inspection. Consent decrees are built over a period of time, generally 3, even 4 or 5 inspections that rendered 483s with a lot of observations and a warning letter, or often case 2 warning letters about different issues. And the reason that FDA brings those cases to DOJ to litigate, and it's worth noting here that FDA doesn't have its own litigating authority, right? So they have to go through the civil division at the Department of Justice. These consent decrees are civil orders, they're civil injunctions. And so they have to go through the civil division at the Department of Justice because FDA can't do it themselves. But, part of our job at the Department of Justice was to vet these as well and to make sure they make a good case. We're litigators, and we don't want to take bad cases to court. And so if you're at a point where you've been handed a consent decree, you could fight it. You could try to negotiate parts of it or all of it. I mean, I have certainly seen cases where consent decrees have come out of FDA and DOJ and then they've been pulled back. Those are rare. And it is probably not going to be enough to say, no, this time we will really remediate the way you want us to. That's not going to get it done once you're past the point of having a consent decree come out of the agency in the first place.
Pete, I just want to turn to you and just put it into context. You were a litigator, associate chief counsel at FDA. Put yourself back in those shoes and discuss how does FDA see consent decrees and what are the criteria that FDA applies to consent decrees?
Yeah, I think, the other folks have already, covered it well. And I was thinking, in line with John's point about usually you've got, multiple violations over a long period of time before the agency also is going to say, hey, this is where we are going to spend our resources, basically going for a court injunction, as opposed to other things to try and get voluntary compliance. And I'm reminded of a line that makes it way into, I think, most of the complaints that get filed, which is something like the company is unable or unwilling to comply with the act. And, I think that's sort of your touchstone there. It's not, they got it wrong once. It's, we have, there's generally a tenor of, we have tried to have a back and forth with them over, multiple instances. And whether they don't want to, or they can't, bring their business into what the law requires. So yeah, so totally, agree that those cases are the ones that the agency sees as most severe. So the process is cumbersome, for sort of everybody involved, but obviously it's an important tool that the agency can, and does use, to show that there are teeth, for people, who again are unable or unwilling to comply. That sometimes that is the measure that you need to take.
Yeah, FDA is not in the business of trying to take regulated products off the market needlessly. They don't want to create shortages. They don't want to deny, commerce. That's never been, in my experience, working with them, what the motivation was. It really is it's sort of that you've got a toddler or a dog or someone who is under your control, and you just throw your hands up and you say, I cannot do this anymore. You have got to, I'm going to court to get an order to make sure you either stop introducing these misbranded products into commerce, or it's that level of frustration at the agency that brings a consent decree out.
Okay, we're going to take a quick break now. Don't go anywhere. We'll be right back. And we're back. We're talking to Hyman Phelps attorneys John Claud, Pete Dickos, and Andrew Hull. And I just want to come out of the legal details that we've been in so far and talk generally about the FDA enforcement environment. We're 11 months or so into this new administration. Again, general questions. I want to start out with John and then turn to Pete and Andrew. What is the current state of FDA enforcement actions? Has there been an increase? Has there been a change from the previous years in terms of FDA enforcement? John, why don't you start out, and then Pete and Andrew pipe in.
Well, we don't have updated numbers for 2025 yet. FDA only just released its assessments for inspections and other enforcement matters from 2024. So there's a lag in the fiscal accounting of what's going on. But and as we talked about this a little bit earlier, we're in the middle of a shutdown, and so discretionary inspections and these kinds of things are at a bit of a crawl right now. But this far into the administration, there certainly are still investigators that are going out to do inspections. FDA attorneys and DOJ attorneys are certainly very active in their chosen areas. But again, those areas are being directed, at least at the Department of Justice, in areas of policy priority by the current administration. And so you get what we've all read about in the papers. You get enforcement actions that are maybe guided by some sort of DEI, anti-DEI philosophy, or some call it gender affirming care, others call it honestly mutilation. That divide is driving policies, is driving subpoenas, and is driving DOJ action. And those kinds of measures that are brought under the False Claims Act as well are really trying. This administration is very focused on enforcing its policy priorities as opposed to a more generalized sort of public health and safety or anti-fraud initiative, in my estimation, anyway.
I'll just, I'll add, I, agree with John. We've seen FDA, components and programs are still going out and doing their regulatory and statutorily required inspections, ensuring that we see warning letters, 483s, all those things are still continuing to go on. But there has been, definitely just some areas where we see changes. I think the big one was the flurry of warning letters that came out. It's maybe a month, 2 months ago on direct-to-consumer advertising.
Yes.
Our colleague Dara Levy did just an excellent job kind of reporting on that in our FDA law blog and really analyzing some of those warning letters. I think that's one of those instances where you really see a different approach with this administration in terms of the priorities and what they're choosing to go after. And then, the same thing that John was talking about earlier about the subpoenas that have been going out to a lot of healthcare systems. We've seen typically the government using HIPAA subpoenas, which are, they're a type of healthcare subpoenas that can be used in criminal investigations when there's generally some nexus between, what's being investigated and some sort of healthcare related crime. And that has been used in the gender affirming care section, where we've seen subpoenas go out to some of those hospital systems, and a good bit of litigation on that's really come out on both sides of the topic. But the overall effect being a real, I think, chilling effect on some of these institutions and providers, which I think is an example where you can see some of the policies by this administration really playing its way into practical effects. Whether there's merit to the what they're investigating, it's that's probably a different podcast, but that's definitely been an area that we've closely been following, and it's been a impact to clients and folks who are concerned about this.
Yeah, it's tough to draw a bead on this because you see sort of deviations from the agency in areas where you thought you had a bead on, what the Make America Healthy Again contingent might want, and it's hard. And the direct to consumer advertising is a great example. You know that Robert Kennedy does not like direct-to-consumer advertising, wants to ban pharmaceutical advertising. I think that there's a real conversation to be had about the merits of the warning letters in the DTC space. Some of those make better cases than others. Again, speaking as a litigator, some of those I might think twice before I took into a federal court. And another example in the medical device space, at his confirmation hearing, Robert Kennedy name-checked the Whoop, wellness device, and then a month or two ago, Whoop got a warning letter for, straying into an area where they were not providing wellness data, but they were actually helping people diagnose a malady, high blood pressure, and so it's really hard. To draw a really tight bead on what where FDA's next enforcement step might be, and that causes a lot of confusion. We have a lot of sort of conversations with clients about what does this mean, what are the different ways, and it really does require you, if you're in this space regulated, to be on your toes.
Pete, I want to ask you about enforcement discretion. Is what I'm going to say now true? And that is, when you were in the general counsel's office, you frequently saw companies coming in and asking for enforcement discretion. Again, I'm going to ask you whether that's true. I'm not making an assertion. I just want to know whether that was absolutely the case. And how does the agency generally feel about enforcement discretion? What are the factors that goes into it. And what are you seeing going on right now?
Yeah. To answer your sharpest question, kind of true. I saw I saw some examples of companies specifically advocating for enforcement discretion, but the interesting thing about it is a lot of the time it is something that the agency has this large amount of flexibility in, and very often it's something that it will sort of take upon itself sua sponte. That it will make its own private decision and announce it to the world. So yes, you do have examples of advocacy by a company. Oftentimes where I saw it, it can happen when litigation is around. But again, a lot of times the agency will do it on its own, and maybe that's a good segue into what do we mean when we talk about enforcement discretion here. I think a lot of people understand the idea that the agency doesn't have to go after every single violation of the Food, Drug, and Cosmetic Act that might come to its attention. We were talking about, consent decrees and all of that. And like we said, it is certainly not the case that every single time a single violation happens at, an industry, FDA is enforcing with the full backing of the law, behind it. It chooses its severe cases and, pursues enforcement for them. But I think what, for enforcement discretion, how I'm using it here is maybe lesser known is how the agency, based on that same principle, the agency says, okay, in a whole swath of products, we have the ability to not enforce, and so we are not going to, and we want everybody to know what we're doing here. And so if I had to sort of summarize the general the general attributes, let's say, of an enforcement discretion announcement, it's something that the agency publicly announces, shares widely. Sometimes it's in guidance. Sometimes it can be just on the website announcement. It can be in letters sent to a group of people. And that announcement is that it won't enforce. Often it is for a certain duration of time. Can be expressed in months, or during COVID, we saw examples of it that were, for the duration of the COVID-19 public health emergency. And then it says, as to what we're not going to enforce against, blank products as to blank violations. And so, using COVID as a concrete example, during COVID, a lot of the normal rules that people conducted themselves by, and that FDA expected people to conduct themselves by, weren't applying. There was a new risk of, you go to a certain place, you could contract the virus, you could expose other people to the virus. And so, for example, during the COVID-19 emergency, there were certain requirements through a REMS with certain drugs that you needed to have imaging or diagnostic labs done in order to receive your prescriptions. And the FDA said, well, look, we know that making people go to their doctor's offices could, risk transmission of COVID-19. So we're going to exercise enforcement discretion with respect to these imaging diagnostic requirements for the duration of the COVID PHE. And then for a lot of them, they added, if that is in the prescriber's medical judgment, the appropriate thing. So lots of other examples. It can take lots of different forms. And last just thing I'd add as a general matter, what makes this interesting and flexible, there's no one governing statute or reg that says this is what enforcement discretion is, this is what the agency does. Like I said, it can kind of very much just say this is what we're doing, and largely, but not entirely, it is something that the courts are unable to review. So it really gives the agency a great amount of flexibility in certain circumstances where they say, hey, we know these have these normal rules, but something different is going on now. Something, special that, is kind of superseding what the normal course is. And so we are going to use enforcement discretion, to give ourselves this flexibility and to give whoever the regulated industry, or patient population is, ultimately to serve some sort of greater public health goal.
In the present administration, do you see more or less or any change in enforcement discretion? I know that any of us sees a limited part of the world.
Mm-hmm.
But based on what you see and hear, what's going on?
Yeah, I would say I haven't noticed any large differences in that area from before. I can think of plenty of examples before, and I know of a few, after. So kind of across, as one example, across the kind of the change in administration, the agency was in a period of stating that it would exercise enforcement discretion with respect to GLP-1s that had been in shortage, and therefore compounding of them was largely permitted. To once the agency had declared the shortage done, that certain, the general large-scale sort of compounding became not permitted of essential copies of those drugs. But the agency said, hey, we understand that this is a spigot. You can't just turn off. Lots of patients have been using these compounded products and are going to need, time for those of them who want to transition to FDA approved products. And those periods, and so it gave those periods upon there was litigation related to it, but basically a transition period was announced, and those straddled the two administrations, without any change in the policy there, and another another kind of recent product transition where FDA said, hey, we are also going to, it was a sometimes compounded, product, but it was an unapproved product that the FDA was saying, hey, we want applicants to come in and submit biologics applications to us, for this product. But we understand in the meantime, that's going to take some time to work up. We don't want to just, leave people high and dry. And that was an announcement the agency came up with a few months ago. So I keeping an eye on it, but haven't noticed anything largely different.
Well, that's something that we all need to keep a watch out for. On that note, it's time to thank our guests, John, Pete, and Andrew from Hyman Phelps, educating us about what's going on in the enforcement environment. I want to thank Hyman Phelps and McNamara, HPM, for sponsoring this series. This is a second installment. There are two more coming. I'd like to thank our podcast creator and executive producer, Michael Levin Epstein, our assistant producer, Sam Hoffmeister. If you want to find out more about the podcast, our website is fdawatch.net. I know you don't want to miss parts 3 and 4 of this series, and the only way to guarantee that you'll be notified is to subscribe to the podcast. It's free. You go to fdawatch.net and put in your email address, and that way you will get notices every time we have a new episode. Our podcast is really growing. We have more than 10,000 downloads since we began. We only started at the beginning of the year. FDA Watch is the only independent podcast that covers FDA, and I think we've had some very interesting episodes that have shed some good insights into what's going on at FDA. As we say at the end of every episode of FDA Watch, if you really want to watch what FDA is doing, listen to FDA Watch.